What's up everyone, welcome back to our page. This video will be discussing a notarial certificate for notarial copies of documents. When you need to have documents signed for copies in South Africa for use outside of South Africa, you will need to go through a process of having the documents authenticated. Now, the nature of the authentication process will depend on the country in which the documents will be used. The notarization of a document is not complete without a proper notarial certificate. Now, the notarial certificate is a written statement signed and sealed by a notary public, certifying the facts of a notarial act. For all notarial acts requiring a certificate, a notary must complete a notary certificate. The notary certificate may be typed or printed on the document itself or on an attachment typically stapled to the document's left margin following the signature page. The two most common notarial acts a notary will be asked to perform are administering oaths and taking acknowledgement. Oaths and acknowledgements are two different notarial acts, therefore each will require its own certificate wording. Requirements for authentication. Documents must be properly authenticated to ensure that they are legally valid for use either within South Africa or abroad. Now, the country in which documents will be used will determine the authentication process that is required. Now, the process of authentication is simplified where the country is a party to the Hague Convention of the 5th of October 1961, which abolishes the requirements of diplomatic and consular legalization for public documents originating in one convention country for use in another. Now, documents issued in a convention country which have been certified by a convention apostille are entitled to recognition in any other convention country without any further authentication. Public documents include documents emanating from an authority or an official connected with the courts or tribunals, including those emanating from a public prosecutor, a clerk, or a process server. Administrative and notarial documents and official certificates which are placed on documents signed by persons in their private capacity, such as official certificates. Recording the registration of a document or the fact that it was in existence on a certain date and official and notarial authentications of signatures. If you have a document which you want to legalize for use in another country or convention country, the convention certification called an apostille must be affixed to the documents by a competent authority. Now, the apostille is a pre-printed form prescribed by convention. Documents are authenticated with a certificate of authentication and or an apostille certificate. Rule 63 of the Rules of the High Court of South Africa regulates the requirements for authentication where documents are signed or executed outside South Africa for use within South Africa. Now, the apostille or the apostille, however you want to say it, a relative simple process can be followed. When the documents are intended to be used in a country that is a party to the Hague Convention, which is dated the 5th of October 1961, a list of participant countries is available on our website provided, which is www.𝗪𝗲𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀 The original documents must be taken to a South African notary public and must be signed or copied in his or her presence. The notary will then attach an authentication certificate to the signed document or copy, which will include the notary's signature, stamp, and seal. Secondly, the notary will then send the authenticated documents to the High Court in the area in which he or she practices, and the registrar of the High Court will sign an apostille certificate authenticating the notary's signature. Now, once the notary certificate and the apostille certificate are attached to the signed or copied documents, the document is ready to be used abroad. Then the authentication process, the apostille process, cannot be used where the country in which the documents will be used is not a party to the Hague Convention. In this instance, the process is then more complicated. Now, the original documents must be taken to a South African notary public and must be signed or copied in his or her presence. The notary will then attach an authentication certificate to the signed documents or copy, which will include the notary's signature, stamp, and seal. Notary will then send the authenticated documents to the High Court in the area in which he or she practices, and the registrar of the High Court will sign an authentication certificate authenticating the notary's signature. Instead of an apostille, the documents must then be sent to the legalization section at the Department of International Relations and Cooperation in Pretoria, DIRCO, where they will authenticate the signature of the registrar. Finally, the document must be sent to the embassy or consulate of the country in which they are intended to be used for their final authentication. Once all 4 steps has been completed, the documents are now ready to be used in another country or in the country that it's intended to be used. Now, the traditional common law maxim acta probant ses ipsa documents proves themselves, that's what it means, applies to the South African legal system. Furthermore, legislation prescribes the formalities for the legally valid execution, signing and attestation, witnessing of documentation when signed in South Africa. However, it stands to reason that the said maxim cannot be applied in respect of a document which has been executed abroad for use in South Africa without grossly and perhaps even unfairly burdening the person bearing the responsibility of judging the authenticity of the documents merely on sight value. Where documents are signed or copied outside South Africa and are to be used inside South Africa, the apostille process is acceptable. Alternatively, any authentication which complies with our High Court Rule 63 should suffice or should be enough. In order to circumvent this problem, the High Court Act 59 of 1959 prescribes in Rule 63 of the High Court Rules of Courts the formalities to be complied with regarding documents which have been signed outside of South Africa. Now, the signing or executing of documents outside of South Africa for use within South Africa. Rule 63 of the Uniform Rules of the High Court regulates the requirements for authentication. In terms of Rule 63, a document is sufficiently authenticated by means of a certificate of authentication which bears the signature and seal of office of, firstly, a head of a South African diplomatic or consular mission or a person in the administrative or professional division of the public service serving at a South African diplomatic, consular or trade abroad. Secondly, a consul general, consul, vice consul or consular agent of the United Kingdom or any person acting in any of the aforementioned capacities, or a proconsul of the United Kingdom, or thirdly, any government authority of such foreign place charged with the authentication of documents under the law of that foreign country, or fourthly, any person in such foreign place who shall be known by a certificate of any person referred to what I've just said up, or any diplomatic or consular office of such foreign country in the Republic to be duly authorized to authenticate such documents under the law of that foreign country. Or fifthly, a notary public in the United Kingdom of the Great Britain and Northern Ireland, England or Ireland, Zimbabwe, Lesotho, Botswana, and Swaziland, or a commissioner of the South African Defence Force as defined in Section 1 of the Defence Act 1957, in the case of a document executed by any person on active service. If you guys want to know more about this topic, please do go onto our website, which is www.lawyers.easyfind.co.za. Alternatively, stay tuned for more videos like this. Click the like button and the bell button and stay tuned for more posts like this.